Hello and welcome everyone. There's still people coming in, so we're gonna give it a few more minutes. And we're, for the first time in a long time, trying to stream this live to other people. So I have this other technical aspect I'm gonna try and confirm is working. So Larry, can you give me a thumbs up if you hear me clearly enough? Sorry, Todd, can you give me a thumbs up if you hear me clearly enough? Designated Todd as my assistant. There you go. All right, we're good. Okay. And I'm also controlling the people coming and going into the Zoom, so I'll do my best. Okay, ladies and gentlemen, welcome. My name is Daniel Charest. I am one of the co-lead counsel for the upstream plaintiffs in the Harvey, Addison, Barker flood litigation. I'm joined by Larry Dunbar and Charles Irvine. Charles is also a co-counsel, co-lead counsel, and the three of us have been working together with our law firms and many, many other people to bring these cases forward. My plan for the day, just so you all have an agenda and understanding, is to do a fairly quick recap of how we got here, the case as it's progressed, and what we expect is going to be happening in the future.
It's not muted.
We always say we'll do the questions,
but it might be on my stupid thing. Okay, I'm going to have to leave and come back
between those two propositions. But I'll say this much, if you have a question that has not been answered, by the time this is over, find one of the three of us and we will find an answer for you to the best of our ability. So don't leave here with questions in your head. Hopefully leave here with answers and at least a sense of what the prospect is. There's nothing certain in litigation, and this one certainly has taken a couple turns that we didn't expect, a couple that we did, but I think we're in as good as a shape as we could hope to be, frankly, given the case, and we're happy with the success of the case so far. So without further ado, admitting everyone else, I'll go forward. On this, how did we get here? Right, if I can make this work. Sorry.
Still the first slide.
Yes, sir. That's the first slide. Bam, here we go. We're here because a very, very large rainfall happened over the Houston area. In fact, the rainfall that fell over Addison Barker watershed, which is effectively the area that funneled into the two dams, was not as big as people say it was. The majority of the rainfall fell further to the east in along the Beaumont area. But it was a very big storm, the Harvey storm, and y'all lived through it, so you don't need me telling you about that. The devastation, both upstream and downstream, was extraordinary, and it caused billions of dollars, frankly, in damages. What people may not know, though, is that the government had been planning for this eventuality, and worse, frankly, for years, decades, in fact. Originally, as designed, the overall flood control structure was to have the two dams that would lead to reservoirs in Addison and Barker, a levee over Cypress Creek to avoid overflow into those reservoirs, and then canals to carry water out and around the Houston area and onto the Gulf of Mexico. Now, that was the plan, but that was not the reality. What ended up happening was that only the Addison Barker dams were built and not the overall structure. And during that, the construction of the dams, and consistent with the construction of the dams, the government bought as an ownership of a certain amount of land. Now, the decision there was to not buy all of the land necessary, and that led to the circumstance we see here today. So the government bought the land that shaded in red, but the flood from Harvey went all the way out to the area shaded in blue. And so that arc around both of those two reservoirs covers your properties and tens of thousands of other properties in the area. That was not a mistake. That was a government decision, and they said it was what they meant to do. So looking at that same kind of concept in profile, what you have is dams, Addison Barker dams, that can hold back, frankly, a lot more water than happened in Harvey. If you look if I can do it, there you go. Each one, the maximum design pool for attics, for example, goes to 115 feet elevation. The Harvey pool was 109. And then Barker, the maximum design is 108. The Harvey pool was 101.5. What that means is fundamentally, the dams are designed to hold 6 more feet of elevation of water. So if your house flooded to 2 feet or 3 feet or 6 inches, imagine another 6 feet of height. That is what the dams are designed to actually hold. But this case is about the difference between the federal lands and the Harvey pool. That 6 feet or so of water that was impounded upstream of the federal lands was placed on private property by design by the federal government. The idea being that the government thought, well, eventually this flood will happen. There's no question that the government believed the flood would happen. And they just decided we'll pay for it later rather than pay for it now. And you don't need to believe me that the government thought that the dam went as the operation went as planned. This is the conclusion, the report by the Army Corps of Engineers saying that the project was performing as expected with no significant problems during this pool of record event. No significant problems operating as intended. The point being, the United States government charged the Corps of Engineers with protecting the downstream interests and did not in that mandate say to do anything about the upstream. They look at the upstream area literally and only as a storage facility. And they do not worry about the impact of that because their mandate, their job, the Corps' job is to protect downstream. And so when the government impounds all this water upstream on your properties to protect the downstream properties, they view that as no significant problems, performing as expected. So what do we do then about that? There is in the United States Constitution, Fifth Amendment, and I'll quote it in a second, but the concept behind the takings clause, which is what we're talking about here, is to bar the government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne by the public as a whole. And what that means is when the government builds dams here to impound water on these private property owners, in order to protect all of these hundreds of thousands of people and millions and billions of dollars, frankly, of property damage and life and physical harm, the greater population benefits from the burden that you bear. And when you bear that burden, you have a right to seek compensation from the government. And that is what the takings clause is about. The source of the takings clause is in the Fifth Amendment, as I said. Nor shall private property be taken for public use. Private property is the areas that were flooded. The public use is protecting downstream without just compensation. And this is an important concept that people don't always understand. And it's that the government can take property whenever it wants. The government has the right as the sovereign to come and take your property, period. The difference is in the Fifth Amendment, based on the original compact between the sovereign and the people, the deal was you can take what you want, government, but you have to pay just compensation for it. And that's what this case is fundamentally about. So that individuals don't bear the consequences of these governmental decisions that help the public as a whole. So Charles and Larry were the original lawyers on the case, and they filed the first upstream action. It's called the Miku complaint. Christina Miku was the first named plaintiff, and the lawsuit was brought under the Tucker Act, which is, without getting into too much of the weeds of federal jurisdiction and sovereign immunity, the federal government has allowed lawsuits for takings to proceed, but they proceed in a specific court under specific rules. It's the Tucker Act, and they're in the U.S. Court of Federal Claims, which is housed in DC, and that's where the judge that has been overseeing this case lives and presides. And that's a sort of ominous picture of the Court of Federal Claims. Our judge is actually quite lovely, a really intelligent, hardworking man with a long history of I think, doing the right thing. And so we got very lucky with the judge. We don't always like the judge yet. He's done a great job. Hasn't always gone our way, but he's gone our way in the important. So from the beginning, there was a case management plan. Lead counsel were appointed, as I said, there's 6 total leadership positions. 3 of them are in the group that represent the folks here in this room. The majority, I think the people in this room are hopefully the ones that are going to sign up. We picked 13 test cases. We picked some, the government picked some, and it was broken into 2 phases, one being liability and the other one being damages. Meaning, the first question is the government liable for this? Is it really a taking at all? And the fundamental things we have to show there are the public purpose, the intentionality behind the taking. Severity. And severity. There's a whole bunch of things, but fundamentally we have to prove that it qualifies for that just compensation. Because remember, the Constitution at base says the government can take for public purpose, then you get the compensation. So we have to show those underlying connections in order to then turn to second phase, which most people think of as damages, but in this context, it's called just compensation. So how did that proceed? We selected the 13 test properties, as I said. The concept was to have people that were spaced around the Addicks and Barker watersheds and have plaintiffs of different types. So people that are homeowners, people that are renters, people that are landlords, people that are business owners. We have a HOA in the group in order to probe whether all of those different types of people, the imposition on their private property would result in a taking. And the answer was unanimously yes. The court found that 13 out of 13 people had stated a claim for taking properly. So they found liability for everyone. I'm kind of skipping ahead. But anyway, during the course of the litigation, we were able to unearth documents that showed, as the government later on said, that they knew about the risk of flooding upstream. They knew that eventually a storm would come that would put water in your homes. They planned for that in order to do their job, but they never wanted to pay for it until the actual flood happened. And that's that goes back from the beginning. Right here we have from the 1940s, talking about the design storm. They say that only chance has prevented the occurrence of a storm over the basin, meaning the area that floods into those reservoirs, that is much larger than the 1935 storm. The 1935 storm was a storm that happened in 1935 that was flooded downtown Houston and caused the government to turn and try and start developing the flood control systems that are around the Houston area. And it says that meteorological conditions that were just like the biggest storm they had seen before then, which is the 1899 storm that they're talking about here in this document, could easily happen over the Buffalo Bayou watershed, and therefore having a much greater chance, a much greater flood event than even the 1935 storm.
And the nice thing about what we went through in the liability phase was the discovery that the government, the army in particular, is generally honest when they write their own documents. They wrote everything down. We were able to use that against them. So they wrote all of these things that Dan is going to show you in a second that we were able to use during the liability phase to show that they always had the intent to flood those upstream properties up to the maximum design pool of the reservoirs.
Correct. The other thing that was going on in these memos that Charles was talking about was recognition of the fact that while the dams were originally built in farmland and fairly rural areas, the city of Houston was growing, and the city of Houston was going to be pressing on the edges of those reservoir structures. So it's one thing for the government to say, all right, we don't own that land, but we may flood it eventually when it's a farm. And when it's a rice field or whatever kind of use that doesn't really require someone's house to be on it. But it's an entirely different thing to use that same property as additional storage capacity fundamentally when people are living in there, having their homes and their lives there. And the government recognized that. They pointed out, this is in 77, that within the next 10 or 20 years, the entire reservoir areas are going to be surrounded. They knew it and they watched it happen. They talked about the fact that the public was not aware of any of these problems. And that should additional lands not be purchased now, meaning the government go out and buy the additional land to allow for storage of this water, the opportunity will probably be lost forever. This is in 1980. They recognized that the time had come to finally either buy the land or be ready to underwrite a much bigger bill when the flood actually happened. And the decision was taken to do nothing and to allow your homes to be the storage capacity. 92, they studied this again and they said the no action scenario, meaning doing nothing, buying nothing, would mean accepting the risk that substantial number of houses will be damaged by rare, severe flood events. They're willing to take that risk and they took it. And they talk about how the storms were coming more and more quickly, more and more frequently, and there was having more and more storms in the past 30 to 40 years. They said the recent events indicate the potential for future flooding problems, meaning they know that the floods are going to come and they know they're going to impound water upstream. But instead, they decided to accept the existing conditions through no action, meaning we're not going to do anything. We're going to allow the places to flood and take the risk that we'll have to be forced to pay in litigation, which is what this litigation is here. So in May 2019, we had a trial. There were a whole bunch of experts. There was witnesses by the government witnesses talking about the actual plans for the dams, and while not all of them were, I would say, perfectly forthcoming, the truth came out. Okay, even the government's own expert agreed that all of the flooding, the maximum level of flooding, was caused by the dam. It was not caused by natural conditions. The government tried to pretend that everyone knew that there would be flooding when you bought your home. We got that expert stricken because his opinions were so off base. Our experts showed the causes of the flood. They showed the reason why each one flooded was because of the dams and not because of other types of flooding. And that the reason that matters is it's only a taking if the dam that the government built is the thing that impounded water on you. So if you're living next to a lake that otherwise would ordinarily flood, then that's not a taking because the government action didn't do anything. But we were able to prove with all of those test properties across both areas of both reservoirs that it was the dams that impounded the water. And that was a hotly contested issue in the trial, which our experts stood up on, and their experts frankly failed completely. And we talked about, we had appraisers in that first phase, but the appraisers in the first phase really talked about severity, as Charles pointed out, which is an underlying question that we have to prove legally. Is it severe? I think everyone here would easily say yes. The government took the position that having water in your kitchen for a week wasn't severe enough. So I don't know where they live, but it must be really easy to clean. You know, it was honestly kind of crazy sometimes, the positions the government took, and a little disheartening that our government would fight so hard and so ridiculously to avoid its obligation. But what happens, I'm going off script here a little bit, but what happens in litigation when someone takes an extreme position that makes no sense is they get punished for it. And they get punished for it here because the government may have had better defenses, may have been more able to make better arguments, but they made these ridiculous arguments and the judge just rejected them all.
Houston's called the Bayou City. Of course, you all know you're going to flood.
Yeah.
So there can never be a taking severe enough to rise to the level of this lawsuit.
It was that level of ridiculous position, I call it. So this is a snapshot of the judge questioning the colonel from the Army Corps of Engineers on the levee, the colonel's left shoulder. The colonel, I forget, the captain. That was the captain. over the colonel, the captain's left shoulder is one of our plaintiffs, and then it's obviously Charles and I. But it was the first time I've ever questioned a witness. We were able to cross-examine him outside of the courthouse on the edge of a levee. That was a pretty interesting event. But I put this up here to show that the judge really went out of his way to understand boots on the ground, literally what was going on in the basin, on the reservoir, how it worked, and in people's homes to see and get a sense of the effect, the actual effect, severity, literally, of the destruction. This is one of our other co-plaintiffs' homes. This is Suarez's home. I think it's on the website.
Yeah.
So, is it here on? Oh,
Yeah.
sorry. And ultimately, the judge issued a decision. We had the trial in May. We briefed it over summer. We argued it in September, and in December 2019, Judge Ledell from the Court of Federal Claims issued a ruling that, like I said, 13 out of 13 of the test properties had proven that there had been a taking, meaning yes, the government is liable. And that therefore the government owed compensation to these 13 plaintiffs. And the idea is, well, it's not a perfect one-for-one match. The idea is the judge wanted to use test properties as, again, there are examples of different types of folks here. Now, most of y'all, I assume, are, you own homes. We would classify you as a residential, victim. We had, I think, 4 and more residential victims. We have plenty of people that fall, and some had like a 1/4 inch of water, some had 5 feet of water, and so there's, all those variations. Everyone, even some people with just water on their property and no structure flooding, every one of those was found to be a taking. So the idea is now we can take those rulings and try and force the same result against the government on behalf of each one of y'all. That's the concept that the judge had. So that was the result of the phase 1, that there was liability for a taking. What does that mean? Well, I just went through this. That includes flooding inside the home, flooding on their property, as the renters, as the businesses, even HOAs. All those types of people were covered by the ruling. And then you turn to the next phase, which is the damages, the just compensation. But before I go there, we're going to talk about a concept. Well, what did the government take? Exactly, it's a taking. They didn't take your property entirely, meaning from a property concept, you call that in fee. When you buy a home from A to B, the standard transaction is a buy in fee simple, meaning I own everything. I own the dirt to the center of the earth and the sky all above me. That's fee ownership is in concept. The government didn't take that. The government took what's called an easement, a flowage easement, a permanent flowage easement. And the permanent flowage easement, what that does is it allows for the government, the owner of the flowage easement, to impose water on your property at something less than permanent state whenever it needs to. Okay? And so you have to stop and put your head around that concept for a second. What the government took was the right to put water in your property, just like up to the level of Harvey, and as long as it needs to in order to protect downstream, as long as it's not permanently on your water, on your property. Now, are there limits? Some, but not a lot. And we're trying to figure out, to be honest, right now, what the limits of that are. And I'm going to cut to the end of the discussion to talk about this briefly. The judge, we had just now a couple of weeks ago, closing arguments on the liability, on the compensation phase. And the judge asked both parties to submit a proposed easement, in writing, what it might look like. And when he decides exactly what that looks like, that will get recorded, and that will be the thing that the government took. So there's different ways to do it. There's different contours to that, and the more rights that are taken, the more value that is taken from you in terms of the property. And we're going to talk about that in a second, but that's still in slight flux. But the fundamental things that we know are true are the government has the right to place water, detained stormwater, that dirty water you had during Harvey, in your property for as long as it needs to protect downstream. That is at least what it has. And it never has to pay you again for the damage that causes going forward. So this taking is the one chance, and this is what people really have to get their heads around, the one chance to get paid for the loss of that right. There's a 6-year limitations window, meaning after 6 years, you cannot file suit, or you can file suit, but you're gonna get poured out right away. 6 years to bring a claim. Harvey was just over 5 years ago, right? So this is, if you haven't signed up yet and you haven't gone on file yet, it's time to do it. Okay, it's time to sign, it's time to get on file. And I just, and tell your friends, I mean, there's a lot of people out, like we know from the number of cases on file, how many people have filed. That's a knowable thing. It's less than half of the people that we think got flooded that actually are on file. Now, are they signed up with lawyers ready to go? Maybe. Are they sitting on the sidelines waiting to see how things go? Maybe. But what I can tell you is on August, well, let's do it this way. In September of 2023, the government is going to look around and say, we're done. We're not liable for any future claims to get filed. And so you want to make sure that you, your friends, your neighbors, everyone that you know that has a situation is aware of that deadline, because it is the most important thing. If you leave here with anything, remember that date. You have to be on file before that date,
And
or face serious consequences.
it's not liable, not just for the Harvey flood, but for all future use of that land of the flowage easement by the federal government. So if the day after the statute of limitations runs, the government has another Harvey event and people file lawsuits, they're all going to get poured out. So not filing a lawsuit does not avoid the imposition of the flowage easement on a particular property. You can't avoid it.
Yeah, the government took this right already. It's happened. It's done. Your only chance to get paid is by filing suit and pursuing your rights. Okay, I'll take a question. Yes, sir.
But there were properties where the water didn't come the property. Okay, but in a larger situation, pool could get larger. What about those people who didn't incur any damage? Can they bring a suit later if they end up?
The question basically is, what happens if there's a bigger flood later, right? And it goes like this. Again, all of this is still subject to the judge writing out his final opinion about what the easement looks like. But what I know from talking with him and the arguments we've had in court, what I'm very, very confident in saying here is that the easement that exists is coterminous with the Harvey flood, meaning in terms of elevation, in terms of aerial extent, wherever the water reached in Harvey as a result of the pool, as a result of the two dams, that is where the easement is. So if there's so the first question is, if that just got on a little bit of my property, but not into my house, well, that little bit of your property is covered by an easement. So that there has been a taking as to that little bit of your property. If it covered your entire property is covered by an easement up to the elevation of the water where it came in. Okay, so 5 feet, 2 feet, 6 inches, doesn't matter. That's the height. So the next question is, if there's another storm, which there will be, and it's bigger than Harvey, which it very well could be, that would be another taking, we would say. Like that's beyond, because the easement rights that are taken are defined by the vertical limit and the aerial extent. So that would be another taking. But that's the more likely scenario, honestly, and our experts did this during the last trial in the compensation phase, is that something less than Harvey but more than government-owned lands happens. Like I think, was it within the 30-year mortgage, it was, what was the percentage? Remember? It was like 50% within a 30-year mortgage that you're going to get some water on these properties. Okay, so that's the more likely result. It could get bigger than Harvey for sure, then kind of get to do this whole thing again. But the more likely result is your Harvey or less. But even then, that is likely to happen. And so again, this is not a matter of, okay, well, it just happened and I'll get them on the next one. They have the right to flood your property up to that level again. And whatever next taking it is going to be from Harvey onward. And even though right now the government's saying that wasn't a taking, we didn't do anything wrong. If they flooded tomorrow, well, if they flooded in a year from tomorrow, they would say, oh, we already bought that. We already took that. And you missed your chance to get paid for that. we're only gonna pay you for this additional inch or whatever. They have the ability and the willpower to make those ridiculous arguments. So that's the best my best answer. All right, we're gonna do a little property law fun. Hold on a second, I'm sorry. I'm gonna, one pause, I'm sorry. Can the folks on the, are y'all still hearing me? I just got logged out apparently with my Zoom. Can y'all hear me still okay? Just thumbs up. Yeah, I see people move. We're good. Sorry about that, everybody. All right, some property law fun. How they come up with it?
Daniel,
School, they teach you that property rights are like a bundle of sticks. No idea who thought of that idea, but it actually makes some sense once you work it through. And so I guess that's why they stick with it. So fee ownership means I own all of these bundles, all of them, whatever they are. The right to do, to exclude others, to sell, to refuse to sell, to use, all of those rights, I own them. And when I start giving them away, they've gone out of my bundle and someone else holds them. Okay?
Selling mineral rights.
You sell your mineral rights is a great idea, a great example. Easements that people are probably more familiar with are, you might have a neighbor and they might drive on your driveway and they have a right to do that. Like somewhere along the way, somebody conveyed the right to use my driveway to my neighbor. That's what an easement is a right to use, a right to enter, less than ownership, but more than most people.
And a lot of your properties probably already have easements on, right? Centerpoint, utilities, Comcast, right? But those easements were created by the developer when they subdivided your property. So when you bought your property, it was already subject to the loss of some of the property rights. And that's what you knew when you signed those title documents, at the closing office. What's happened now is an additional easement has been imposed on you. So that's the loss of an additional and probably a more significant property right than you ever agreed to when you first bought your properties, right? You don't care about the Comcast easement at the back. They come and cut down some trees occasionally once every 10 years. You don't really care about it. But that's what you negotiated when you bought the property. But now the government has come in and taken a significant additional easement that basically could destroy your home again.
And those utility easements are a really good example for a couple of things here. Number one, the utility easement, well, it lasts forever. And so as long as you own the property, that easement exists. And just like that same lesson is applied to this one. This easement, the right to flood water, will last on your property forever. Forever is a long time. Okay. And when you think about property rights, you have to think about like generation after generation forever, and it's going to happen. Number one. Number two, they have the right to, as Charles pointed out, come on your property and maybe chop down some trees or whatever. Well, you might love that bush, but if it's in their easement and they have the right to do it, they're going to take it and there's nothing you can do about it. That is within the rights that are granted in the easement. But another example is if you go more than, if the easement owner exceeds, to the question I had earlier, exceeds the right in the easement, you can have a claim against them. And a personal example I have is I had a power line in the back of in the alley between my neighbor's house. It fell down, set the fence on fire. Well, that was beyond the scope of the use, and so they had to pay me back for the fence. But the point being, there's limits to what the easement does, but this easement is pretty broad and will allow, as I said, water to flow on forever. So how do you value that is the next
Excuse me, Daniel.
many different ways. But every easement depends on let me put it this way, it depends on the amount of rights taken, right? The impact it has on the remainder is really the concept you want to think about. So I had my property before, the right has been taken away, the remainder is what we're valuing, the delta, the change in value of the before and the after. And we're getting ahead of myself, but that's the concept there. This is a matrix that was developed by appraisers. It's been published and well known. And it lists, where are we now? Flow easements at the top right-hand corner as having severe impact on surface use and on conveyance of future uses. And this particular expert pegs the difference at 90 to 100% of the value. Meaning, if your home is worth $200,000, they would say that the imposition of a flowage easement on that property makes it now worth 90 to 100% less. So 200,000, what's that, $20,000 max. Okay, meaning the value of the thing that was taken is $100 to $200,000 in value. All right, that is what this expert suggests.
Because anytime you sell that property, it is sold subject to that easement. And that's what we struggled with in, I mean, I wouldn't say we struggled, but that's what we had to deal with in the compensation phase, right? What is that difference? Because at some point, you're all going to sell your properties. And at some point, the Corps of Engineers is going to record the easement. And so when you sell a property, what is the difference that a buyer will pay? But Dan will get to that very soon.
Yeah. So we have, sorry, we had the actual compensation trial. We, for purposes of sort of efficiency, I guess, and also for focus, the judge wanted to reduce it down to 6 test cases. So there were 4 individual, four residential properties, 1 landlord and 1 renter, to try and test out those different scenarios. We didn't do any for the business owners and the HOAs; those were all still in abeyance. It was a 9-day trial that ended in June 10th. On June 10th, we had 29 witnesses. That includes all 6 of the plaintiffs. We called 8 government witnesses. Most of these folks are people within the Corps who are going to be charged with enforcing the easement, talking about the regulations around the easement and what rights the government thinks it took. And then there were 7 plaintiffs experts. The government called 5 experts and 3 additional witnesses. So it was a lot of work, a lot of fun, honestly. If you don't like trials, you're in the wrong business. We did patting ourselves in the back here. We did a great job, and we came in very, very well. So what was the focus of the trial? There are some sort of concepts that bear understanding about the law. Yes, good. Yes, sir.
This was in what year?
Sorry, this was this past summer, this May. Sorry, I apologize. I jumped ahead a little bit. We had May 2019 was the liability trial, and then between that ruling was in December of 19, and then we had some time early on trying to fight about like what the next steps were, and then we had COVID, which delayed a lot of process in the court, shut the courts down. Then, candidly, well, just like the government did in its actual litigation position, it played really hard, really tough with trying to get information out of it. Let me put it that way. They were taking care of your dollars, so I guess in that perspective, it's good. But they made our life really hard, and they made your recovery much more difficult to get. And we went up that mountain a bunch of times. But we got the information we needed, and ultimately we had the trial in May of 22, and concluded in June of 22. So, and then over the course of the summer, we did the briefing, just sort of the same schedule as the first one. We briefed over the summer, hundreds of pages of briefing and citations to the record and why the facts that we found mattered. And then we just had the closing arguments in that trial in DC in 2 weeks ago. There you go. So what were we trying to focus on? Just hearing us talk about what an easement is and how to value it, you might wonder, like, how does any of that make sense? And to be candid, it is a bit of a black box. You get appraisers, they do their bit, and each one of them has their own different methodology, but ultimately the judge has a lot of discretion in terms of trying to fashion the award. And it's based on the judge's impression of the facts that presented. But the fundamental notion is that the government has, as we put here, a clear and categorical obligation to pay just compensation. And the way the courts articulated is whatever the government takes, it has to pay. And so what did the government take from the test properties and from the all-posts? The first one is real property value. Now, we talked about that in the easement. Like if someone just walks up to you, the way they articulate it is this: if a buyer and a seller have agreed on all terms, willing buyer, willing seller agreed on all terms to sell a house, and a regular transaction, and just before they sign, the easement is imposed. And they say, oh, by the way, now I get to flood your house whenever I want to, as often as the weather requires, as long as it's not permanently underwater. And then those same buyer and seller agree, we're gonna still transact, but now they have a new price. Because they know what the terms of the easement are, and they know the effect of the easement and the risk that's imposed. That delta is supposed to be the theoretical, mental gymnastics that the appraiser goes through. So that's the effect on the real property, is the value diminution as a result of the imposition of a lot of big sort of mushy words, but that's the concept.
Before.
But yeah, and that's, we describe it more simply as the before and the after. We'll talk about that in more detail in a second. The other aspect of what was taken from these test properties and also y'all is the loss of enjoyment and use. So when your house is flooded, it wasn't like you could sit in your living room and enjoy it in the way you usually could. The measure of damages there is basically the rental property, the rental value of your home or that property during the duration of the displacement. So in effect, the government is renting out your home from you while you're not in a position to use it. Now, how long does that last? There's experts that can talk about how long it took to move back in, individual discussions about I was out for 6 months, I was out for 9, whatever. But those are that's the moving parts. It's the rental value of your home by however long you were out of your home reasonably. Some people never bother to rebuild, can't just stay out forever and collect that money forever. There's limits, but everyone knows. I mean, the first client I met, I went with her to go buy a washing machine because they were on sale that week, and it was like that day, and they were just, it was days after the flood. I mean, it was the chaos, y'all know. So I'm going to really tell you, but trying to put your house back together again wasn't like call, the handyman. They show up the next day. We understand the struggle of it, and we try to express that to the court to show 9 months, a year wasn't unreasonable, for being out. And the third part is the personal property. Now, the government fought like hell on this, to be honest, but we convinced the court, and I think correctly so, that even though when the government flooded your couch and flooded your salt and pepper shakers and your rugs and whatnot, that's not really necessary for the taking. That doesn't help. That's not like for the public purpose. But rather than tell you, hey, we're going to use your home, and therefore you need to move everything out, they just impose the water. And so the manner of the taking, we successfully convinced the court, I think correctly so, that the government should pay for the physical impact of that too. So you talk about like I said, it's just your personal property, your car, the things you own that got destroyed as a result of the flooding, rather than because the government doing it as an inverse combination versus a combination. And every time I say that, I pause myself and remember that not everyone knows what that means. So I'm going to take another sidebar on this one. And that goes like this. A lot of people are aware of like the notion of the condemnation case where the government wants to build a road, I-10 expansion, whatever it is, and they come and knock on your door. They say, oh, look, we want to buy 20 feet of your property. We're going to take it. And because it goes, the government can take whatever it wants. We're going to take this property. Here's an offer on what we think it's worth. The owner can say, I think it's worth more, and they can have a fight about that. And sometimes that goes to litigation. That's called a combination case, where the government has announced, I'm taking this, and there's a fight about the amount. Here, the government...
In that case, the government sues you as the landowner to eventually take your property and have a court determine the value. Yeah.
In this case, the government took by action and not by some sort of imposition of its right, and forced us to sue the government, and that's why they call it inverse condemnation. So first we have to prove that it wasn't taking, that's the liability phase, and now we're having the fight about how much it's worth. That's the just compensation phase. So that's what those terms mean. I'd just like to make sure everyone's clear on that. So these are the three categories, buckets, measures of damages that we talked about in the trial and in the work of the trial. And I'm talking, we had probably 20 experts working on this, trying to figure it all out, both in terms of making sure we don't double dip, but also making sure we don't miss. Because again, this is the one chance you have, and we wanted to be as complete as we could in the presentation to the court about the harm and impact on y'all. So there is oddly enough, a book that the government uses called the Yellow Book on how to do appraisals. And Charles mentioned it earlier for the real estate appraisals. It's called the before and the after method. So what does that mean? The before method is when the home is dry and it has no easement imposed on it. So it's dry and unencumbered, you would say. And that's in my example of the two willing buyer, the willing buyer and willing seller, they agree on terms, they agree on price. House is in good condition, or it's in whatever condition it is, but they both know it. They're both aware of all the issues that they need to make the decision, and they proceed. That's the before. Now, the after is, imagine going up to the home in Waiters, with the water having just receded, couch floated into the corner, mud everywhere, silt, everything destroyed, and you're sitting there looking at the impact of this easement. That's the after. And so our task, the task that our appraisers did, was to say, okay, what's the before value of all these homes? That's a pretty relatively mundane, frankly, issue. Everyone can kind of, there's methodologies around figuring out what the value of homes are. People do it all the time. They're appraisers, and they're trained to do it. But the after is the one that takes the skill and the art, because now they have to put themselves in the state of what is a willing buyer and a willing seller going to transact for this house with mud up to my ankles, with a water line at 2 feet, and all the destruction is there. What's that worth? And that was really that's the and not only what is that worth as a result of it being wet, but also knowing full well that there is now an easement on this property which did not exist before, that allows this same destruction to happen anytime a major storm happens to be over top of these watersheds, anytime. And that's the burden of the question that the appraisers have to address. So we had 3 different appraisers on the plaintiff side. Tim Archibald was one. He was born and raised in this area. He worked in this area. He was here during Harvey. His house was a little bit further upstream, and so it didn't flood, but he was out and about helping people on the day after the flood, after the water receded. So he knows full well the effect on the people and the sort of local populace. His estimate was between 85 and 95% in value, meaning a reduction in 85 to 95% of the original value. Matt Deal is an appraiser also in Houston. He did a slightly different approach and used case studies around town, and I don't want to get into the technicalities of it, but looking at places that had suffered repeating flooding and trying to evaluate the effect on prices there. His, on average, diminution was around 82% for places that were the structure flooded, around 82%. He's the lowest of our experts. The third gentleman, named by Randy Bell. Randy Bell is about as good as you get in terms of in the world of appraisals. He appraised the World Trade Center after 9/11. He appraised the Bikini Atoll as a result of nuclear experiments. I mean, he's done worldwide top tier litigation and appraisals, and we were lucky to have him on our team. In fact, after we hired him, the government tried to hire him on their side. He's that good. But he declared for us, and so we were lucky to have him. Anyway, his number was between 85% and 100%, based on a whole series of analysis that he went through, and he left a big wider range there because of the uncertainty around the terms of the easement, which you're gonna learn is that uncertainty going away hopefully before too long. Another point that's important to know is that the government regulations, this is the Army, a snippet from the Army Corps of Engineers regulations, and the Army regulations require, the Army regulations require that this easement, when written, will be recorded. And that's an important concept to understand, because right now, people are buying and selling houses up in attics and Barker reservoirs, knowing that it flooded, probably. Maybe not everyone knows, but most people know that it flooded. Maybe understanding that another big rain will result in another flood. but for sure not knowing that an easement actually exists right now on those properties. They don't understand that. So what the buying and selling that you're seeing is not a real reflection of what will happen in the market, we believe, when people become more fully aware of what's really going on. Because if you walked in here knowing that there was an easement on your property, I bet you're in the minority. And if you know what the terms of that easement are, you're the only one, because I don't even know what the actual terms of that easement are. So I would say that it's impossible for those transactions that are going on and have been going on to really reflect the market value of what's going to happen. But what the Army Corps of Engineers regulations tell us is that when there has been a case that identifies a taking like this, they will get that easement recorded in writing, whether it be from the judgment of the court or getting someone to convey them an easement, which we don't recommend. But ultimately, the judge will write an opinion describing what the easement is. The Army Corps will take that opinion and record it of record to protect its interest now, because now the Army Corps owns that easement and it wants everyone else to know we own it. So that when the next buyer comes, they can't say, you don't have the easement because I didn't know. The impact of that, our experts tell us, will be dramatic, because at that point, when someone goes to buy a house and they go for a mortgage, they run a title search. The title company is going to hit this easement and not know what to do with it exactly, but they're going to take it and put it on a shelf and say, look, we, the mortgage companies, we, the title insurance companies, what they like to do is things that are easy. They book the title, they run the title, they book the mortgage, they package it and they sell it off to some bigger company. That's what they do. And if they can't do that process, they won't offer them the mortgage. All right. And the concern is if people aren't able to get mortgages to buy the properties, that's going to take buyers out of the market, which makes the price go way down. So I'm just telling you, as the best advice I can give you is, you can expect, I hate to say it, but you can expect the value, the sale value of your home to go down once this thing gets reported. And the government will record it. It is their regulations. The judge is right now thinking about how to draft and articulate what this easement is. And when the government gets it, they're going to run to this county courthouse and record it. That's what their regulations tell her. And when that happens, our experts tell you're going to see a major shift in the market about the ability to sell these homes going forward. That's terrible news, and I'm sorry to be the one to tell you, but that is the result of the government's taking here ultimately.
That is what our appraisers are still in.
Right, and that's why the appraisal numbers are so big, honestly, because they say, look, if the value of the home is going to go down that much because of this easement, the government owes you the value of the home. And I'm going to pause on that for a second. No one here, I don't know what your personal motivations are, but I've never met anyone that's in these cases to get rich. And I say this to the court whenever this issue comes up. The only thing people want to do is be made whole. That's what they're entitled to under the just compensation. The concept is, if I take X from you, I'm entitled to X. That's it. Not X plus, not more, just what you took. Okay. But the idea then is to understand what was actually taken and put value to that. And that's what the entire just compensation trial was about.
And understand one thing. Whether or not you filed a claim for this lawsuit, or whether or not this lawsuit ever happened, the government has taken that permanent closure on everybody's property that flooded during Harvey by the pool. It has happened whether you file a suit or not, whether you file a claim or not, it doesn't matter. The government has taken. And as Dan said, after about 6 years, the government will eventually put in the real property record evidence of that permanent flow easement on all those properties. Whether you filed a claim or not, whether you had a lawsuit or not, whether this lawsuit has or not, it doesn't matter. So what is this lawsuit doing? It is confirming that, yeah, there was a taking by the government, which we all kind of already knew. But more importantly, how much does the government owe all of you for taking your property?
and making the government pay. Because up till now, the government hasn't acknowledged that they took your property, and they haven't paid you for it, not that I know of. So that's what this lawsuit is about, and that's why if you want to get compensated for the taking of a current board meeting that they basically already have done, you have to file a claim.
Even if Larry and I hadn't filed that, nobody else can file that. I think it is. But the government would still argue that in Harvey, they took from the code. Now, the lawsuit does not create a threat, right? The lawsuit just gets the compensation.
And whether you file a claim or not, if you don't file a claim, the government still took a current board meeting on your property. And the question is, you want to get compensated for it? If you don't get compensated for it now, you will never get compensated for it after that 6%. Oh, some hands.
We're almost to the end. We're almost to the end. Please, just give me a second. Sorry. Yeah.
But I want to take you that point, because I've heard people say, oh, I don't want to file a lawsuit. I don't want to do anything in court. I don't like lawsuits. And some people said, oh, that lawsuit, that's what caused all. This lawsuit did not cause anything. This lawsuit is trying to get compensated for what already happened.
All right. So these are just, I mean, these are just individual people. I'm showing now the slide we used in the closing arguments for temporary loss of use. This is the being out of your home for a certain amount of time. Now, basically, this is the rental value by an amount of time, but I'm just trying to show in a range of numbers the types of damages people were able to at least allege by the to the court. For the that's for the temporary displacement. The personal property, basically, think of it as the depreciated value of your personal property now. So if you bought a couch for $2,000 in 1988 and it flooded in 2017, it's going to be less than $2,000 worth of value. The government doesn't pay for the original value; it pays for the depreciated value, replacement cost. Okay, that's the notion. And so again, these are individuals, and so they don't mean much to y'all, but it gives you a range of the amount of personal property that was lost by these folks, and what you might be thinking about on your end as well. And then we have a whole bunch. These are again slides from the closing. I just want to show you the kind of concept that we had. We had for each person, we combined the real property, the temporary loss, and the personal property, and gave a total in a range, high or low, because again, the judge looks at all the data we provide and then makes his judgment based on the facts that are before him. And so this is Ms. Miku. Mr. Holland was a renter, so his, like, he doesn't have temporary loss, for example, and he has lesser rights. He has like a month of lost rent. And so basically for renters, it's personal property is the real recoverable. Mr. Sidhu is a landlord. So he doesn't have really much of temporary loss because he wasn't displaced, although his renter was lost, was up for a month. Right. But he's got real property losses. Doesn't have a lot in temporary, doesn't have a lot of personal property. I mean, he owns some of the equipment inside, that's why he has some of it all. And then for Vici, hers was a house that had flooding all around the house itself, but not in the structure. So her damages are slightly different, but still pretty significant because the water in her situation covered a lot of the property. So if you have people that had water on a lot of property, but not in the house, we view their claims as valuable, and they should protect their rights. Again, like Larry said, it's up to y'all if you want to sue, but if you don't sue now and the same flood happens 2 years from now, you're not going to have a chance to recover that. And this is, well, anyway, there's more and more people, more claimants. That's basically was the result of the just compensation trial. So where are we currently? This is a transcript from the hearing that we had a couple weeks ago on September 29th. And we had the hearing up in DC. And the judge said, basically, all right, well, look, I've never actually articulated exactly what's in the easement. He gave us all the material points, the elevation, the aerial extent, the right to flood, intermittent right to flood, consistent with the project, those types of things that mean a lot to the appraiser, but he never put pen to paper and described exactly the easement. So he asked us then, excuse me, to submit us first, the plaintiffs first, and the government second, proposed language for an easement that he intends to then craft, from which he intends to craft an easement and file for either use by the government or for review by the appellate court. And so he asked us to do that on a fairly expedited basis. Ours was submitted, was it last Friday? I guess it was last Friday, a week ago yesterday. And we gave, sort of did a half what he wanted. We gave him a bunch of options. The idea being, look, we're not trying to advocate, let me put it this way. From the lawyer's perspective on your behalf, we were trying to advocate for the smallest easement possible, meaning the least imposition. The first one we ever put forward was, we said, okay, well, you have the taking, you have to pay for the personal property and the effect of it, and you can use it going forward, but every time you use it going forward, you have to pay us again. Because that way you'd be as protected as you could be and you retain the rights you could. We took the tactical decision to try and argue for the minimalist easement, the smallest easement possible. The court rejected that original view. And he just did. So that means there was a more permanent easement. That means fundamentally that's why what we think the compensation for this one is so high, because you never have the right to ask for more damages later. And so you're getting paid now for all of the future floods. Okay, and that. Right. So then what we referenced that fact earlier for that prior submission and ruling, and then we submitted two more. One being what I view as the more moderate easement. Again, we're trying to advocate for the lower end because from our perspective, you're better off holding your property rights and getting cash today. But you know, that's we don't really have much control. But that's what we advocated for. And then the other one being a more maximalist easement based on what the Corps' regulations are and what the Corps, how we think the Corps will actually use the easement. And we use that to show the court, look, here's a range, like our experts gave you a range between 85 and 100%. If you go the lower one, it's more like 85. If you go the higher one, it's more like 100. And then the court can do whatever it wants to in that range. And ultimately, the point of the message we hope that the court gets is understanding that the more he takes from y'all, the more he should require the government to pay. And that's not only, that's just fair, right? That's just. And our whole point is, again, we're not trying to make money. We're just trying to be paid back. Y'all are just trying to get paid back for what was taken from them. So the only other piece of news I can relay that of real note from the closing arguments is that the judge says he's trying to get his opinion out by October. So that's pretty fast. And again, I said before, and I said again, we have a really good, hardworking judge, and hopefully he does what's right. What happens next is he'll issue a ruling. There'll be post-judgment, post-trial briefing, so that won't go right away. But ultimately, we'll get to what's called a final judgment. And at that point, the government will either appeal because it lost, and we know it lost because it already lost liability. And the question isn't whether the government owes us money, but how much. And so it'll appeal that ruling, or it could come talk settlement. We don't really know. They haven't had any interest whatsoever in talking settlement so far. I mean, like literally emails unresponded to, kind of no interest. But that might change once there's an actual ruling in hand. We don't know. So we'll see. You know, we're always open to that discussion. But that's where we are right now. Is we expect a ruling in a month. I expect to probably get to final judgment in the first quarter of 23, and then it's either going to be an appeal or some discussion around settlement. Now, before we go to questions, I want to say one point on settlement, because this is a question I get all the time, and I just want to put it out there. We will never settle your case without your express consent. Okay, what I mean by that is, if you are our client we are not going to settle a case unless you say, yeah, that is a deal I will take. Okay? The idea is we understand kind of where people are, and, like, we have to be the conduit for that communication, but if you are signed up with us, we are never going to settle. We can't, and we wouldn't settle without your consent. And so you have to just understand that, like, people, there's a lot of talk. I know, I've heard it about, oh, these lawyers do X, these lawyers do Y. All I can tell you is that we tried the case, we know the case, we're working really, really hard and spent millions of dollars, billions of dollars, more, millions and millions of dollars to prosecute the case so far. And we're doing it all on the notion that we're trying to get money from y'all, for y'all. And then the idea is we share in that reward. So if you get money, we get money. So our only chance of getting repaid is to make y'all get money for what was taken. So that's the idea that I want to make sure everyone understands. We're not going to settle out from underneath you. We're working on your behalf for your best interests. And that's the nature of the contingent fee case, is that your case becomes at least a little bit our case, and that's why we fight so hard for it. So, questions, anyone? Questions, sir?